voicemail. Good morning, Mr. Munley. You may proceed.
Good morning, Your Honor. Members of the bench, may it please the Court, Robert Munley for DSCI Corporation. I should note at the outset, by the way, my condolences over Judge Sussman. At issue today are Verizon resale restrictions with respect to a customer-specific pricing agreement with the Commonwealth of Massachusetts. I'll refer to that as the COMA CSP and a customer-specific agreement as a CSP. DSCI had planned to take the COMA CSP, resell it, and use it to serve virtually its entire customer base in Massachusetts, over 20,000 access lines. This was important to DSCI because its then current serving arrangement, which the Unbundled Network Element platform, was expiring under federal law and needed to find other alternatives.
Can you explain that? I don't really know what that means.
Which part of it, Your Honor?
That something was expiring and you needed to develop a new delivery method or something?
Yes, there was. Under federal law, there was a type of serving arrangement called the Unbundled Network Element platform, which is something closely akin but not identical to resale, but it allowed competitive providers to offer services at cost-based rates. And then the FCC issued a decision that essentially decided that the UNEP should be phased out. It gave a one-year transition period. And so at the start of the one-year period, DSCI started looking for other alternative arrangements, tried to work on what the solution was during the next year. It settled on CSP resale with the Commonwealth CSP and perhaps other CSPs as its approach it wanted to take. And then days before the end of the transition period, Verizon changed its position and said it was not available for resale, except to a very limited class of subscribers. So DSCI was not able to handle that and do its preferred.
So what does it do now?
It uses more expensive forms of resale available from Verizon.
From Verizon.
Yeah. So this is a first impression issue in the Commonwealth. It's virtually a first impression issue nationally. And despite very strong pro-resale provisions of federal law, both in the rules and in the statutes, and the fact that Verizon at no time contended that there were cost differences or other measurable terms of service differences between the aggregated DSCI customer base and the state, local agencies, and other commercial entities that were served under the Commonwealth, the COMA CSP itself. The Department upheld both restrictions with very minimal analysis and unpersuasive analysis. Both rulings should be reversed. I'd actually like to tackle the second issue in our case first. It's straightforward, and I can dispose of it quickly and get to the main issue. The second issue is that even assuming that DSCI is limited to that limited class of customers that the Department and Verizon agreed it could serve using CSP resale, the Department denied DSCI the ability to combine the per-line rates in the COMA with usage rates in another Verizon discount program, the corporate rewards program.
You said in your brief that Verizon has now conceded that was error?
Yes.
All right, so you're really arguing relief at this point?
Certainly from my standpoint, although the Department did not concede error.
Oh, okay.
I certainly want to point that out. Verizon, in its brief, did essentially say that they did not understand what DSCI was looking for. They thought that they were seeking relief under one usage plan, and we're going to combine that with the corporate rewards usage plan, and that they thought that that was inappropriate. And if that was what DSCI was trying to do, we'd agree it was inappropriate. You can actually look at our reply brief. We have some fairly substantial citing to point out that we were very clear what we were looking for from the start. On its part from the Department's essential position on this is it denied the resale of that because it said that DSCI was limited to a different CSP that it had to use for usage, what's called the Customer 38 CSP, which is another CSP with the Commonwealth. The problem with that position is that there's no citation to the record to support that proposition below, other than and there's no, in the decision itself, and in the brief itself, there's no citation to the fact that that would somehow, DSCI would be limited exclusively to the COMA, to the Customer 38 CSP. It's just not there in the record at all. And if you look at the COMA CSP tariffs, the Customer 38 tariffs, nothing between them says that they must be exclusive. In fact, there is positive tariff authority as well. If you look at the record at page 229, there's a provision in there that notes that for CSP customers can't get the access line discounts available under corporate rewards, but are, quote, eligible to subscribe to and receive the benefits of all over other corporate rewards components. So, I mean, that's the game plan. It doesn't allow for you, they want to avoid you having double discounts, but in this case, all DSCI wanted was an access discount.
Well, is DTE's decision in essence based on an argument that Verizon made, which it now concedes was error?
Certainly, that's one way to look at it. I don't. Again, the council will have to speak for the department what its views are.
Okay.
We certainly think that there's no grounds for it, that it was done in error, and that it should be reversed as an error of law. And then to Justice Cordy's point on the relief, it is the question of what you should do. Certainly, we sought declaratory rulings. It would make sense to have declaratory rulings come from the court invalidating the restriction. The question is just what's the appropriate date for that. You certainly could do just the department's decision date last year, or you could go back to the date where Verizon first made the error, which is when it first denied the application back in March of 2005.
So explain to me, DSCI has been able to sell the CSP COMA to eligible entities, or be able to provide, so you've got some of the eligible entities, the nonprofits or whatever,
yes,
under this plan?
It theoretically could. The problem is that without able to have a usage component with it, DSCI's customers aren't interested in it.
All right, so you're not selling to those eligible entities?
Not to my knowledge. It's conceivable there might be a couple of customers, but I don't think that there are.
Okay.
So what's the remedy on this second issue?
I think
Verizon says dismiss that part of it as moot.
Yeah, but we've been denied discounts for over 2 years now. That it now concedes we should have been receiving. We should have been eligible to receive.
So you're looking for damages for the 2 years?
I don't know that it's damages, but certainly what you could do is if you make the declaration to that date, DSCI will work with Verizon to figure out what's the appropriate. Again, these are still Verizon customers. It's just a question of what the rating is going to be, both going back to the date of the declaration and going forward. Turning to the principal issue, this is the one that. Your Honor, did you have a follow-up or?
What?
Oh, did you have a follow-up?
Well, no, I was just quickly looking at the brief of Verizon, and they seem to say the department's finding on that issue was correct, and so does the Attorney General's brief.
The department's.
Where do they concede that there was error?
Yeah, the department brief concedes that there can't be a customer 38 and a corporate rewards. If you look at their brief at pages 31 and 32 is where they say that, now it's clear that DSCI is only looking for one.
One or the other. Okay.
And therefore we agree with that. Turning to the principal issue, which is the issue that instead of letting them serve the entire customer base, they can only serve the eligible entities. The department's analysis ignores its burdens under federal law, and it necessitates reversal as an error of law. It's also lacking in substantial evidence and arbitrary, but I think the error of law is the cleanest shot at it. The first point is that under federal law, Verizon is required. The contract is presumably, the restrictions are presumably invalid, and Verizon has the burden of proving that there's no discrimination. If you look at the department's decision, which is pages, it's in our appendix, the pages 10 to 12 of the decision. Yeah. There's no analysis at all of discrimination except for the second to last line where they conclude that there's no discrimination. There's no analysis at all. They just conclude it. The same with the second one, which is the reasonableness prong. Again, they have to prove no discrimination and that it's reasonable. Again, pages 10 to 12, no analysis at all of reasonableness except for the second to last line where they say, therefore, it's reasonable. The third issue is that what the department did is there's a third federal requirement, which is as part of Verizon's ability to get access to the long-distance markets, the lucrative long-distance markets, they committed to the FCC that they would permit CSPs to be resold to similarly situated entities. And if you look at the standard, it's reproduced at pages 5 of our brief, and if you look at the last 4 or 5 lines of that, it talks about that the competitor, the CLECs, can aggregate the traffic of all of their end users, the multiple end users. Actually, there's multiple end user customers. And then it says, provided that those customers are similarly situated to customers of Verizon's original contract. The proper test for similarly situated is the end users. You look at the DSCI, who DSCI is going to sell it to, which in this case is a multi-location commercial accounts all across the state. And then the Commonwealth has their end users, which are commercial nonprofits located all around the state. And again, there's no, in the record, Verizon has never identified any quantifiable difference between the end users. What the department did do is they went the wrong standard, which is they said,
They looked at the procurement.
they did, and they said that the procurement processes between DSCI and the
And the
Commonwealth,
Commonwealth is onerous and burdensome and difficult and complicated, and you've got to adjust and yakety yak, 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 and it's tough to do business with the Commonwealth.
which I'm sure it is in some respects. It's also tough to do business with large commercial properties as well, because they have the same dedicated staff, they have the very complicated RFPs, they have all the same things. But the important part in that is that the department applied the wrong legal standard. Instead of looking at the end user differences to be similarly situated, they took it up to the level of DSCI and the Commonwealth as the procuring entity. It's the wrong standard. It should be looking at end users, which makes sense. I mean, if you have, in order for something to be reasonable, non-discriminatory, it's important to look at, you want to make sure that you're not getting a scam here, that it's some type of bad deal. If there's a particular type of serving arrangement that has specific cost issues or specific service term issues that are there that differentiates it from the person seeking to resale it, then you can deny resale. But in this case, there's no such differentiation. There's no reason to deny it. That's what you should be looking at. The department should be looking at the quantifiable factors that make one set of end users different from another set of end users. They didn't do it. They jumped to procurement practices, which, and it's the wrong standard. And again, this is another error of law here. They missed three of them: reasonableness, discrimination, and the similarly situated test. The only thing
Mr. Maloney,
Sure.
would I be correct in understanding you that you would exclude look at any procurement difficulties? So when the department, points to terms and conditions in the Commonwealth Standard contract that prohibit termination liability and then, muses or Verizon likely opposes the resale and so on and so forth, you're saying that's irrelevant.
Yes.
Don't even look there. That's just not relevant to our inquiry.
It is irrelevant.
Okay.
Because for a couple of reasons. One of them, as is in the record, and there's a lot of evidence in this on the record, almost all these provisions are also in private contracts as well. The decision says that termination liability is likely a rarity. Well, it is likely a rarity, except if you're dealing with a Fidelity or a Bank of America or other large user. They have the same big RFPs, the same dedicated staff, the same everything that the Commonwealth have, as other than that they're doing it as a matter of sound business practice, as opposed to, in market power, as opposed to applicable state law. But even more importantly, it doesn't really make any sense on its own terms. The way CSP works is you have to, it's a below-tariffed agreement between parties. So irrespective of how it comes about that this procurement opportunity is offered to Verizon, Verizon has to voluntarily accept it. And it has to find it as reasonable under the department's standards, and then it has to tariff it. And the reason it's tariffed is a safeguard, because otherwise you could have Verizon coming out and offering a thing that if it can't be resold, then they can underprice other competitors. So there's no reason why something happened leading up to a CSP should be dictating what happens with a CSP that's been approved and established for the department. You should be looking at the quantifiable factors on that and meet all the three tests: non-discrimination, reasonableness, similarly situated.
And would I be correct in understanding that that your as you say, this is, if not a first impression, it is here, maybe elsewhere. There's not a lot of case law scattered throughout these.
Yeah.
But I would look at the application of Verizon. Is that what you're pointing me to say? Look, they knew what they were doing when they were focusing on customers.
The similarly situated test, yes, it's in the intralata order. It's also in several other decisions around the country that are cited in our briefs.
Okay.
I did want to say, it's one thing this is a rarity just because it takes a special CLEC to try to do this. A CSP can be a moving target. It can change year to year. You have to be willing to dedicate the resources, shift around, and it's hard work for most people. DSCI is willing to take this and try to offer innovative services to to customers, and that's the important thing. Just in conclusion, again, this is not the department's finest day. First impression issue that gets the back of the hand without very much supporting analysis. The DSCI certainly was harmed by this, but also customers were harmed. There was an opportunity here for DSCI to take advantage of the opportunities to offer new innovative services, and it should be reversed.
Thank you, Mr. Manley. Is it Manley?
Manley.
Great.
Thank you
Mr.
so much.
Manley. Mr. Barnacle?
Good morning, Your Honors. May it please the Court. My name is Thomas A. Barnacle, Assistant Attorney General, and I appear for the Department of Telecommunications and Energy. Couldn't disagree more completely with the argument just heard. The Department rested its decision in this case.
Your argument's kind of a common sense argument, which I may have wrong, but as I understand it, because of this contract with the Commonwealth and related entities, they get very low bargain rates, right?
Yes, Your Honor.
And Fidelity doesn't?
And for them to turn around and say, well, we want to give these very low rates that result from a rather unique procurement system to ordinary commercial customers.
The volume certainly drives a very low price, but it's not on volume alone that the Verizon relied or the Department. And it is not on the procurement process alone.
No, I understand. I was pointing to one of the arguments that you make.
Right. Well, I think it's more of a characterization of the group of factors, all of which are supported in the record, all of which were identified by the Department in this case. By that I mean that it's not relying on the procurement processes, the fact that Verizon must go through legally specified steps in order to contract with the Commonwealth in a matter of this type. It's rather the outcome of those processes produce terms and conditions that govern that contract, that precisely speak to differences in the manner of service, the terms of the contract, how it's administered, matters different than ordinary commercial arrangements. That's what's different. It's not.
Why? I mean, I hear the argument, but I'm trying to understand why it would be different than, we'll take a Fidelity, we'll kick Fidelity around. It's got, say, 20 or 30 different sites around the state and has got the comparable volumes, comparable procurement processes. Why?
Well, one of the main differences was this list of hundreds of eligible entities. The Commonwealth is free under the contract at will to continue to designate through the term of the contract different eligible entities, the various nonprofits, subdivisions of the Commonwealth, all of which contract with the Commonwealth and can be changed through the term of the contract. That presents to Verizon a variety of management problems, if you will, risks, burdens that wouldn't exist dealing with a single commercial entity. Instead, it's hundreds of different entities, not under the same.
And the Commonwealth is the only one, the only procurer that has such provisions?
That's what the record certainly supports. And a reasonable mind, looking at this record that was developed in front of the Department, with testimony by Verizon about how unique this arrangement is, with the Department making judgments about the market, Verizon's own operations, they had the right to rely on these hundreds of eligible entities as a very different arrangement than arrangements in the usual commercial setting.
Again, I'm missing the point here. It sounds to me like what you're saying is the arrangement with the Commonwealth is an expensive one to supervise and monitor, but that should be reflected in cost differentials, which DSCI says you haven't demonstrated any cost differentials. It's not going to cost you any more to provide services to the Commonwealth entities than it costs you to provide other services.
Well, I think as a matter of common sense, this major difference, it could be inferred that it's going to be a more
different. But you
difficult.
can't do that. You've got to have a record. I mean, I don't know. I really don't know whether, as a matter of common sense, it would impose greater costs, because you could have one corporate entity with endless sites. I mean,
but the cost.
Maybe I don't know this, Mr. Barnico, but I've been trying to put every courthouse in this Commonwealth. Right? I've been trying to get computer systems, and there's one entity, but it is really different when I go to Greenfield or the Boston Municipal Court.
Well, cost, it wasn't Verizon's burden to identify simply as a matter of cost these differences.
No.
We're talking about a very broad standard here about whether a certain group of subscribers, taken as a whole, are similarly situated or not to the competing entities or the entities that DSI wishes to provide. And if I might add a couple of...
They have to be reasonable and
right.
non-discriminatory.
That's right. And of course, whether something's similarly situated is a key aspect of any claim of
Sure.
discrimination in any context, and usually it's a rational basis type judgment that applies, and substantial evidence here is akin to that judgment. If I might mention the other factors, though, that the Department relied on, again, I couldn't disagree more that the Department didn't go through the precise federal laws that are on point, allocated the burden directly to Verizon, and then identified these factors as justifying a difference in treatment. They're the ones we have been discussing about the large list of eligible entities, the right of those entities, or the fact that those entities would produce significant management burdens, the fact that the contract is renewed at will by the Commonwealth, the fact that the contract has a prohibition on any liability for termination by any of the eligible entities or by the Commonwealth
but
itself.
with respect to each of those, and I don't want to go round and round, Mr. Munderly says lots of other contracts have that, and Justice Cordy says, yes, but then reflect it in the cost. That's what you would normally do. It's complicated, it's difficult, I've got really, you know, I can be terminated at will, so I'm going to make you pay more.
Right. Well, there'll be a number of those that will be could be reflected in the ultimate price that's reached between Verizon and the Commonwealth. But those are distinguishing, our argument is those are distinguishing features which in and of themselves justify Verizon and justify the Department in determining that this contract could be considered to be unique. It may be true in a private setting like Fidelity. These matters could be matters of negotiation. But they're always matters of negotiation. In this case, Verizon's required to accept each of these terms, and the Department could reasonably decide that with these terms enunciated by the legislature and by regulation, I should say, they provide the differences sufficient to determine that this is a unique contract and that the Commonwealth and its train of 700 eligible entities is a unique category of subscribers. Government's different in this respect, and Verizon so doesn't bear a federal obligation to hand that contract over to DSCI.
Okay. Mr. Barnico, when you said, and I think I understand you, that the Commonwealth, when Verizon is negotiating with the Commonwealth, it's really, it's not an open bargaining because they have to accept certain things.
These terms, right, that would be extremely contentious with someone like Fidelity.
But surely Verizon's option then is not to enter into the contract with the Commonwealth. In other words, I don't know what Fidelity, and I don't know why we're picking on Fidelity, maybe because it's just a big user, but I mean, if Fidelity said, take it or leave it, I'm going to have this as, I can terminate at will, I've got no termination liability, so on and so forth. You know, Verizon can try to argue, and Fidelity says no.
Well, that may be true, but in this instance, Verizon has no choice but to accept at least those terms. I agree with Your Honor that it's not a compulsory contract with Verizon, but once they do reach the business judgment that they should enter that contract, notwithstanding these terms extremely favorable to the Commonwealth.
What's the economic impact were we to agree with DSCI on Verizon?
Well, I think I'll let Verizon address that.
Does the Commonwealth, I'm not asking you as representing DT, but does the Commonwealth as the customer of Verizon have an interest one way or the other as between Verizon and DSCI?
Only the hypothetical I could think of would be that it would make the Commonwealth CSP less valuable to a CLEC or an ILEC if they were competing for that business, if they knew that what they believed to be such a unique arrangement would be subject to the resale provisions of
Okay.
federal law.
Okay.
So I think that would be the answer.
Thank you, Mr. Varnica.
Thank you. We do ask that the court affirm the decision of the department on the second issue. We think we decided the correct issue, and we think we decided it correctly, so it should be affirmed for the reasons
Regardless
in
of
our
what Verizon's
Right.
position. Okay, thank you, Mr. Varnica. Mr. Moore?
Thank you. May it please the Court. My name is Alex Moore for Verizon New England. The Chief Justice just asked the question, the economic effect on Verizon. There was testimony that we offered before the DTE stating that if the resale is allowed here, it would effectively reduce our tariffed rates that are available to all business customers, because all business customers, all private sector entities would be allowed to enjoy the low rates and the other favorable terms under COMA that are now limited to the eligible entities. As a result of that, we couldn't any longer afford to offer the Commonwealth such favorable terms, because we know that that offer then becomes our de facto rates. So that not only would it be economically...
Let's assume that that's correct, Mr. Moore, but if you're wrong on the law, doesn't that mean that when you're negotiating with the Commonwealth, you take that into consideration? Stated differently, shouldn't you have taken that into consideration, or didn't you take that into consideration when you were negotiating with the Commonwealth?
If we're wrong on the law.
Yeah.
But, and I'll get back to that in a moment. But there's also a policy concern here.
Okay.
Because one of the policies, the state has, as sovereign, has passed statutes and procurement regulations. And in the beginning of the procurement regulations, they state all the good things that they want to come from this, all the public policies being supported by the procurement regulations. The first one is to get favorable terms and rates, the best value for the Commonwealth, including vendors that serve the Commonwealth, so to keep the cost down low for the Commonwealth. If this resale is allowed, Verizon is one bidder that won't be providing such favorable bids in the future. We were the best bidder, that's why we won. But we won't be providing those favorable terms in the future. So there is a policy concern there that's maybe separate from the rest of the analysis. On the issue of the law, Mr. Munnelly says Verizon didn't offer any evidence of the cost of service distinguishes the eligible entities from private sector companies. There's no law that says that that is the only factor the State Commission should look at. There's no law that says that's even necessarily a relevant factor in every case. When the FCC delegated the authority to the State Commissions to decide when a restriction on resale is reasonable and non-discriminatory, it didn't promulgate any regulations explaining or limiting how the State Commission has to go about its analysis. It didn't say you must look at cost of service. In fact, the FCC itself created a restriction on resale that has nothing to do with cost of service. In the federal regulations, this is 47 CFR section 51.613, which is the regulation concerning resale. In Part A, the FCC says, we are not going to allow companies to resell services that are intended for residential customers. You can't resell those to business customers. And in the local competition order, the FCC explained its reasoning, and it was all policy. Its reasoning was that many states effectively
provide for lower, when you're providing to residences,
they subsidize residential rates by higher business
sure.
rates. And if you allow a resale, you destroy that subsidy. So in order to encourage universal service, the ability for every individual to afford phone service, they said, we're not going to allow that resale and destroy that subsidy. But there is no discussion there. There's no mention of cost of service as a differentiating factor between residential and business customers. Mr. Munnelly cites on the related standard of similarly situated, Mr. Munnelly cites to a statement in the Interlata Services Order by the DTE regarding similarly situated. That, in fact, is a statement by Verizon. It's not a holding by the DTE. And the statement is only that Verizon agreed that if a company wants to resell a contract of Verizon's, and that contract has a volume requirement, Verizon would allow the reseller to aggregate its customers to meet that volume requirement, provided that those customers are similarly situated to Verizon's customer. Those are two separate requirements. There's a volume requirement that some contracts have, and Verizon noted those customers must be similarly situated. There's no discussion there or intimation that similarly situated means you have to look at cost of service. Let me address some of the questions the bench had on these factors that distinguish this contract and this entity from private sector entities. It is tough to do business with the Commonwealth, but it's more than that. Many of these requirements are required by law. Fidelity can drive a hard bargain, big customer.
No, I understand, but
We can't negotiate with the Commonwealth on that there won't be any termination liability. They don't have to give up any chits in the negotiating process
just
in order to
going
get
in,
that.
yeah.
And the DTE found that that term is likely a rarity in the telecommunications industry, and also that it alters the fundamentals of basically the rest of the contracting process. That's one. In the hearing before the DTE, the witness from Verizon was questioned on some of these things, and we very much disagree with DSCI's characterization of the evidence. There's no voluminous evidence that private entities have all of these characteristics. We agree, of course, private entities use RFPs. Private entities can't impose their will as a matter of law with no discussion. Private entities don't name hundreds of other follow-on customers. In fact, the witness on cross-examination testified, effectively agreed that theoretically there could be such a thing where a buyer signs a contract with Verizon for others. But she also said Verizon hasn't done it. She said Verizon doesn't enter into a contract with one person to serve many others, other than this one.
Mr. Moses, I don't even know if this is in the record, and I don't even know if it's relevant, but do we know whether in other states where there, presumably, I don't know whether every state has a single, provider such as Verizon here, but do other states, do the people in the entities in Verizon's situation, are they required to permit resale for the state entity?
I don't think the issue has ever come up.
Okay, do you want to say a word about the usage rates?
Yeah.
The second issue?
Sure.
Where do we stand on that?
We concede that there is error, but we don't concede that we erred. We concede that DSCI erred below. And the way it works is, just as a note on resale, when a company resells our contract, we still provide the service. They buy the service from us and resell it to their customers. So we're still providing
And I assume
service.
that that's where just so that I understand, DSCI thinks it can be innovative because it's whatever it's getting from you, they're going to provide to the customers and you different, and presumably there's some spread in there so they benefit as well.
Well, right. They buy it from us at an 18% discount on it for whatever the rates are. The usage rates is an interesting issue. Our position is that once DSCI clarified before this court that all it wants to do is resell COMA with this corporate rewards discount program on top of that, we agree that they can do that. That was not clearly the issue before the DTE.
Right. They were trying to combine two discounts.
Exactly. COMA provides rates for lines. We charge by the number of lines a customer uses. We also charge by usage, the number of minutes. COMA doesn't say anything about usage. But Customer 38 is a separate CSP with the Commonwealth that does provide usage rates. It was negotiated in the same way, the bidding process and so on. And as we say in the briefs, our tariff prohibits using two discounts for usage. The corporate rewards program doesn't provide any rates. It's just a matter of discounts. It only provides discounts on usage rates provided elsewhere. What DSCI is essentially saying before the court is they want to resell COMA, they want to resell Verizon's tariffed rates for usage, and on top of that, layer the corporate rewards discounts. We say they can do that.
The decision of the DTE, you would agree on that point, was correct.
Absolutely.
Right.
If you have a usage plan, which Customer 38 is, you can't layer corporate rewards on top of that. That would give a double discount, and that's prohibited by the clear terms of the tariff. I think DSCI agrees with that. The issue that DSCI now asks the court for new relief that wasn't sought below at the DTE, and they ask the court to engage in fact-finding and decide when Verizon knew or should have known, maybe an objective standard, that DSCI only wanted to resell corporate rewards on top of COMA. But that's not at all clear from the record. DSCI, in the complaint to the DTE, in its prayer for relief. It asked for an order ordering us to let them resell Coma and Customer 38.
Now, can I, because I don't really understand, what can DSCI now do with Coma? You said they can resell it, but to whom and how, if they can't resell it to their commercial customer base?
That's right. They can resell it to eligible entities.
If those eligible entities combined provide the volume required, or can they pick off a couple of eligible entities and just sell the package?
It depends if they meet the volume. They need to get eligible entities that would meet the volume requirements. They can. That's who they can resell Coma to, if that's the only issue.
Thank you.
Thank you, Mr. Moore.
Thank you.